Hey y'all, welcome to Criminalist Behavior Podcast, the podcast that takes you deep into the heart of Louisiana's history and current, most chilling true crime stories. I'll be guiding you through the darkness of these crimes and all of those involved. Each week, we dig deep on those forgotten crimes or those crimes currently happening with the underlying legends that continue to haunt us. So lean in, listen, and get ready because true crime is anything but ordinary. Stay with me as we unravel what happened in these mysteries. So today we're on episode number 47, and this is called the Exonerating the Underdog, a journey with Patrick Brown. So if this is your first time listening, hi, my name is Sarah Soudier. I'm your host for Criminalist Behavior Podcast. I want to thank you for listening to the show, and I hope you enjoy it. So, trigger warning, this episode may contain content of a graphic nature, including descriptions of physical and sexual violence against adults, children, and animals. Listener discretion is advised. So, I wanted to let my listeners know I got this whole podcasting setup thing going on, and I'm still tweaking some of it. I had it working perfectly earlier, and then I don't know what the hell happened. All of a sudden, it's not working correctly, so I'm back to my old recording ways. So y'all bear with me. I promise y'all by the first of the year, hopefully I got it all set up and figured out, but it is a work in progress. I got the microphone, the little sound bar, and then like the different programs, but oh my god, it is a task. I just want y'all to know I have been working on it because I do know that people said that my sound isn't that great. So I wanted to make sure that I fix that. So I got all these little equipment gadget things, and let's just say I'm not a tech savvy person. And yeah, it's a work in progress, so bear with me. And I just want to make sure y'all get y'all content. So I'm going back to my old ways on how I done it before. Okay, so excuse the quality of this sound. I promise I'm going to fix it. So I'm going to jump right into the case now. Get over with all that banter. So I'm going to take you on Ash Wednesday, 1994. 6-year-old Lila was at home of her maternal grandmother, Patricia's, who generally kept her during the school week. And this was because of the child's complaints. Patricia noticed that her granddaughter's bottom area was raw, and she attributed this condition to Lila's all-day exertions on Mardi Gras and the fact that the child had not bathed before going to bed that Tuesday. So she thought, could have just been something wrong, dirty, whatever, sweaty, whatever, and just didn't bathe properly. It should go away, right? So Patricia gave her a bath and applied some diaper rash medicine to the affected areas. When Patricia went to pick up Lila after school on Thursday, she learned that the child had cried most of the day and appeared to be in severe pain, saying she had a severe stomach ache. Lila was given her dinner and some Pepto-Bismol and then sent to bed. Patricia phoned the child's mother, Kathy, and told her that Lila needed to go to the doctor. She needed to take her to the primary care doctor. Something was seriously wrong. The next day, that Friday, Kathy went to Patricia's and saw that Lila had a yellowish-greenish vaginal discharge. She took her daughter to Charity Hospital, where she was given some Lotrimin lotion and told to return on Monday. As usual, the child spent the weekend with her younger siblings in Kathy's household, and that time included 3 men in Kathy's household. They had Kathy's boyfriend, Patrick Brown, her father, Lawrence, and her cousin, Lamar. Because Kathy had another appointment that morning, Lila was brought back to Charity Hospital Pediatric Emergency Room by her maternal great-aunt, Carolyn, on Monday, February 21st, 1994. The nurse noted in the medical records that the child was there for a follow-up for a vaginal discharge. And a pediatric resident, Dr. Ronald D. Wilcox, did a general physical exam on her. Based on a visual inspection of the discharge, Dr. Wilcox suspected that Lila had a sexually transmitted disease, probably gonorrhea or chlamydia. He sent Dr. Maria Mena, a board-certified pediatrician assigned to the hospital's child sexual abuse clinic, before proceeding any further. They waited, and Carolyn phoned Patricia and summoned her to the hospital immediately. She called her. She needed her at the hospital because this child, yes, I said child, is suffering from an STD. She is 6 years old, y'all. 6 years old. How in the hell can this child have an STD at the age of 6, right? So, upon arrival, Dr. Mena agreed that it appeared that the young child had an STD, indicating that an assessment for possible sexual abuse was necessary. After a preliminary discussion to reassure themselves that Lila was actually safe and could talk freely, the doctors asked Lila, has anyone ever touched her inappropriately down on her bottom that would make her feel uncomfortable or that would hurt her? The child initially said no, but after further assurances from the doctors, Lila began to cry and said, "My daddy Patrick stuck his penis in me down there." Yes. She said her daddy Patrick stuck his penis in her down there. Now, let me bring it back a little bit. Patrick Brown is not Lila's father. That is Kathy's boyfriend. Lawrence is Lila's father. So she is indicating at this given time that Patrick Brown stuck his penis inside of her, and Dr. Wilcox immediately recorded her statement in his notes as she pointed to her genital area and used quotation marks to indicate he had written exactly what she said. The doctor testified after a long period of time, stating that this information was necessary for the diagnosis and treatment of Lila's vaginal discharge. So they wanted to make sure that in the event that a sexual trauma or anything like that did not occur, they needed to figure out what other means would be causing this nasty discharge on a 6-year-old that appeared to be an STD, such as gonorrhea or chlamydia. So, through further questioning, additional details of Patrick Brown's alleged sexual attack on Lila was obtained and documented in a 6-page sexual abuse examination form. A complete pelvic exam revealed evidence of vaginal penetration occurring a couple of weeks earlier, in which was consistent with Lila's story. The physical findings were recorded in the child's medical records as well as on a separate sexual abuse form, and photos of Lila's vaginal area were made using a colposcope that magnified the images. Swab samples from the child's cervix and rectum were later confirmed positive for the bacteria that causes gonorrhea, which had an average incubation period of 2 to 7 days after having sexual intercourse. This child, let me repeat, this child is 6 years old and has just been diagnosed with gonorrhea. That is fucking sick. That is just pure sick. After the medical examination, 2 detectives assigned to the New Orleans Police Department's Child Abuse Unit spoke with Lila with no other family members present. They then interviewed Patricia. When Kathy and Patrick arrived at the hospital, the officers gave them a brief explanation of the situation, and they advised that Mr. Patrick Brown was advised of his Miranda rights. Both Kathy and Patrick Brown voluntarily accompanied the detectives to the police headquarters for further questioning. After executing a formal waiver of his rights, Mr. Patrick Brown denied any inappropriate behavior with Lila or any of Kathy's children, explaining that he was rarely left alone with them. Despite Patrick Brown's denial, he was arrested immediately based on the medical evidence and the child's statements. Child Services removed Lila from Kathy's custody and placed her in her great-aunt Carolyn's home. Kathy was shocked and enraged by what had been done to her daughter. She believed that Mr. Patrick Brown was incapable of doing this heinous crime. That whenever he denied any wrongdoing towards Lila, she stated that she believed Patrick Brown. She, in fact, accused both her cousin, Lamar, and the father, Lawrence, of molesting Lila. And this prompted an STD testing on all three men, Patrick Brown, Lawrence, and Lamar. And results dated February 24th, 1994. For Lamar, the cousin revealed that he had a yeast infection, but he was not positive for having gonorrhea. Lila's grandfather, Lawrence, was tested February 28th, 1994, and his report also came back with a negative finding for gonorrhea. It was stipulated at trial that when Patrick Brown was tested on March 25th, 1994, the results indicated that he previously had a gonorrhea infection. There was no testimony or evidence at trial suggesting that sexual abuse had been suspected, much less discussed, by anyone in Lila's family prior to the second visit to the pediatric emergency room. Although Carolyn had remained with Lila throughout the doctor's examination on February 21st, and Patricia had joined them in the examining room at some point, Dr. Wilcox explicitly testified that no one in the room had mentioned the name Patrick or Patrick Brown, or even used the word penis prior to the child's statement regarding what had been done to her. In addition, the doctor denied having used leading questions against Lila. It was also explained that Carolyn had been Lila's primary caregiver until the child was about 4 years old. Carolyn testified that when Lila was about a year old, she began asking questions about the difference between boys and girls. Carolyn responded by showing the child pictures and teaching her the words penis and vagina, as well as more common terms she might hear on the street. Well, kudos to Carolyn, because, that is something that you wouldn't have to want to explain to a 4-year-old, much less a 6-year-old, but, not in an explicit form, but just so they can know the difference between boys and girls. I think that is a good thing to do, and I think Carolyn was in her right to do so. So, Kathy was called for both the prosecution and the defense when this all went to trial. She confirmed that Lila had been raised for the most part both by Patricia and Carolyn, and that child sometimes used the name Daddy to refer to their boyfriends as well as to her grandfather, Lawrence. While Lila also called Patrick Brown Daddy, Kathy had never heard her call him Daddy Patrick. Kathy testified that in early 1993, both she and Patrick Brown had contracted gonorrhea and that she had a discharge at that time that was similar to Lila's. She also explained that she had initially accused her father of abusing Lila because sometimes he would get drunk and fall asleep on the living room floor, but in the morning he would be in the bed next to her children. Y'all keep that in mind. This man got drunk, fell asleep on the living room floor, and then when she woke up, this man was in her children's bed. The grandfather of these said children was in the bed with these children. Okay. Keep that little thought in your head. So, although she seen Patrick Brown, she sent a letter to Patrick Brown expressing her love and support in April of 1994. By the time of December 1994, at that trial, she no longer believed in his innocence. She, in fact, then at that trial in December of 1994, she believed that Patrick Brown was actually guilty of touching her daughter Lila and giving her gonorrhea. So Lila, who had who at age 7 at the time of the trial, was called to the witness stand twice during the trial. Although she was able to answer preliminary questions regarding her competency from counsel and the court, once the jury was brought in, she began to cry and her nose actually began to bleed due to all the stress and anxiety. So Lila was removed from the courtroom, and the judge cautioned the jurors that they were not to be distracted by the incident nor influenced by sympathy or passion. After an off-the-record discussion between the counsel and the court, the judge stated that sidebar is denied. So, at this point, Lila was then recalled to the stand, and the prosecutor was able to get information concerning her age, family, address, and school. However, after demonstrating that Lila knew the difference between a truth and a lie, Lila was unable to respond to questions regarding the consequences of telling a lie. And when her nose actually began to bleed, again, she was removed from the courtroom and another witness was called. The state later asked to recall Lila back to the stand, but the court ruled that because the child's composure appeared no better than the first go-around, it was not going to make her be a risk for the potential prejudice of further dramatics in the courtroom. So despite the defense's counsel attacks on the testimony and evidence in the closing argument, the jury did find that Mr. Patrick Brown guilty of aggravated rape of Lila. So Patrick Brown was found guilty for aggravated rape against Lila. He did file several appeals and assignments of error. So, the fact of assignment of error number 1, sufficiency of evidence. There was substantial medical evidence to establish that Lila had been raped. Mr. Patrick Brown states that the evidence was insufficient to support the jury's verdict that he was actually, in fact, her attacker. And he argued that even if Dr. Wilcox's hearsay testimony was properly admitted, he is entitled to an acquittal under Jackson versus Virginia. So, hearsay evidence is usually objected in the courtroom. You hear it all the time. Objection, hearsay, objection, hearsay. So they cannot basically go off of just hearsay evidence and just the guilt or innocence of a particular crime. So, with that being said, the standard for the review of the claim of insufficient evidence is firmly established in Louisiana law. So, an appellate court reviewed the claim of insufficient evidence, and they stated that they must be able to determine that the trial evidence, whether direct or circumstantial or mixture of both, were most favorable to the prosecution in the guilty verdict. So they had to prove that it was sufficient enough to convince a rational trier of fact that all of the elements of the crime have been proven beyond a reasonable doubt. And that means that all the elements must be sufficient that every reasonable hypothesis of innocence is excluded in that verdict. And if rational triers of fact could disagree on that evidence, stating there is a possible flaw and there might be reasonable doubt, then that evidence is not most favorable to the prosecution and it must be withheld. However, if the appellate court finds that there is evidence that is favorable to the prosecution, the decision will be upheld. So basically, if there was enough evidence, whether it's circumstantial or factual, to prove guilt or innocent, then they will go that route. So, State versus Hawkins court case, when the defendant's identity as a perpetrator is at stake, Jackson versus Virginia requires the state to negate any reasonable probability of misidentification of a suspect. So, while they were reviewing the records to determine sufficiency of evidence in Lila and the Patrick Brown case, a jury's credibility decision should not be disturbed unless clearly there was evidence that was against their ruling. So, Mr. Patrick Brown argued that Lila's father and cousin were also living in the household with Lila at this time, and that only their testimony, rather than medical reports, were presented to establish that they both tested negative for gonorrhea shortly after the rape was discovered. Patrick Brown emphasized that Dr. Wilcox recorded Lila's statement as identifying "my daddy Patrick" as her attacker, even though no one had heard her call Mr. Brown Daddy Patrick before. So instead, it was shown that the child called several men daddy, including her grandfather and cousin, Lawrence and Lamar, but Patrick Brown stated that this evidence of Lila's extreme dysfunctional family situation and the circumstances under which she was living was enough reasonable doubt to identify him being her rapist. So, however, viewing the totality of all of the evidence in light, this was actually most favorable towards the prosecution, and they found that there was sufficient enough proof to convince a rational fact finder beyond a reasonable doubt that Mr. Patrick Brown committed the rape of Lila, a child under age of 12. They based that decision, y'all, only off of the gonorrhea medical results. So basically, just because Lawrence and Lamar did not have gonorrhea and Patrick just got over having gonorrhea, that is, even though it's circumstantial and there was no evidence to say that Patrick Brown actually was the one, could have just been a coincidence, is what was being argued by the defense, that is actually sufficient evidence, and they proved that the jury was without a reasonable doubt enough to convict Patrick Brown of aggravated rape. So, with that being said, the medical testimony established that Lila's hymen had been damaged and enlarged by vaginal penetration, probably by a penis, keyword probably, and her vaginal discharge was confirmed to be that of a symptom of gonorrhea, which obviously is transmitted by sexual contact. It was also stipulated that a test be performed 1 month after Lila's diagnosis and approximately 6 weeks after the rape to establish that Mr. Patrick Brown had previously been affected with the same disease. In addition, the child explicitly identified the defendant as the rapist, saying that he had stuck his penis in her down there 2 weeks earlier, whenever she was brought to the emergency room the second time, right? So, due to the contradictory evidence noted above was put before the jury and rejected, despite the emphasis given to his defense counsel's closing arguments, evidence presented satisfied Jackson versus Virginia, and there was no reasonable doubt in their conviction of aggravated rape against Patrick Brown. So, another assignment of error that was filed for Patrick Brown was the admissibility of hearsay, right? Mr. Brown stated that the trial court erred in admitting Dr. Wilcox's testimony as to Lila's identification under Evidence Code Article 803, basically stating that a hearsay exception for statements made under certain medical purposes. He argued that the circumstances under which the statement was made do not support the interference of reliability necessary for the admission of hearsay, and that his conviction must be reversed. So, Supreme Court noted in False versus False, decisions regarding the admissibility of hearsay testimony are to be made on a case-by-case basis. Keeping that in mind, it is clear that the legislature had expressed an overriding interest in protecting child victims of sexual abuse by encouraging the admission of reliable hearsay evidence for the trial court to weigh. Basically, stopping the child from having to testify on the stand based on the hearsay evidence, whether it was recorded in any type of interviews, forensic interviews, or any of that nature, it is going to be weighed in court. So, the following are excluded by the hearsay rule, even though the declarant is available as a witness. So, statements for purposes of medical treatment and medical diagnosis in connection with treatment, statements made for purposes of medical treatment and medical diagnosis in connection with treatment and describing medical history, or past or present symptoms, pain, or sensations, or the inception of general character of the cause or external source thereof as reasonable, pertinent to treatment or diagnosis in connection with treatment. So, this was part of the redactor's comments of the provision. It is noted that Louisiana's exception followed Federal Rule Evidence 803, but it excluded from coverage statements made solely for the purpose of diagnosis. The comments also indicate that the statutory language has been interpreted to limit the scope of exception to the kind of statements that are usually relied upon by doctors in their diagnosis and treatment of patients. So, Mr. Patrick Brown acknowledged that his statement identifying the perpetrator of sexual abuse, especially when communicable STD is suspected, is reasonably pertinent to obtaining medical treatment in a proper way and generally been held admissible under federal counterpart of this exception. He argued, however, that in this case, it cannot be inferred that Lila was motivated to respond truthfully to doctors' questions. And Mr. Patrick Brown stated that there was no evidence that the 6-year-old understood the purpose of the questions, and notes that Lila initially denied that anything had ever happened. He further maintained that because she made her statement only after several minutes of continued prodding by her grandmother and great aunt, the two adults who had raised her, her identification was likely motivated by her desire not to displease them by remaining silent or naming someone else in the household. Patricia admitted at trial that she had told Lila she did not like Patrick Brown and Lamar was Carolyn's son. So, in support of this argument, Mr. Brown cites Cassidy versus Maryland, in which it was held that a young child's statement to a doctor identifying her mother's boyfriend as the person who had physically abused her 3 days earlier was not admissible under the state's counterpart to the medical treatment hearsay exception. The Cassidy court based this ruling in part upon the fact that there was no indication that that 2-year-old victim for that particular court case understood why she was being questioned in the first place. So, Mr. Brown's reliance on Cassidy is misplaced, according to this. So, that Cassidy versus Maryland trial that he tried citing was the same as Maryland court emphasized only 9 months later. Therefore, can be a vast difference between the cognitive development of a 2-year-old and that of a child only a few years older at age 7 at the time of trial. In this instant, Lila was 6 years old at the time of her examination, 7 at trial, but she was described as being bright and articulate, absent of any indication of a mental defect, and was reasonable to infer that a child of 6-year-old understood the purpose of a medical exam and the doctor's accompanying questions. Furthermore, it was apparent that Lila had been suffering for several days from an unexplained vaginal discharge, providing a connection, obviously, even to a 6-year-old, to the doctor's inquiries about being touched in her private area. So therefore, they rejected Patrick Brown's challenge to admissibility based on Lila's age or her alleged lack of understanding. So, in that case against Maryland, they stated that the victim, Rachel, was just a few weeks shy of her 5th birthday when she developed vaginal bleeding. It distinguished Cassidy because upon the age difference and the sexual abuse was indicated, the Maryland court held in the Indiana versus Rachel case that the child's statement to a medical social worker identifying her father as a perpetrator was admissible under medical treatment hearsay exception. So, they found no basis for Patrick Brown's contention that the identification was inadmissible based on the circumstances or setting in which Lila's statement was made. His claims that Patricia and or Carolyn influenced the child either before or during the doctor's questioning were explored during a defense counsel's cross-examination of all the witnesses. However, there was no testimony indicating that anyone in that family had mentioned the possibility of sexual abuse to Lila, much less suggested that a particular individual might be her perpetrator. So while Patrick Brown's attorney was permitted to argue in closing that Lila's use of the word penis, as well as the unfamiliar name Daddy Patrick, which he was never called, could mean that the child had been coached, the minimum evidence supporting this contention is insufficient to establish that Lila's statement was inadmissible. So under those facts, they found that there was no error or abuse of discretion in the trial's court determination that Dr. Wilcox's testimony relating to Lila's statement was admissible under Evidence Code Article 803, the medical treatment exception to the hearsay rule. So that merit of error was denied. So then Patrick Brown went with the confrontation clause. He argued that Lila's failure to testify violated his right to confront and cross-examine his accuser, as guaranteed by the Sixth Amendment of the United States Constitution. He asserted that the legislature has acknowledged the importance of this right in child abuse cases by providing for the use of closed-circuit television under certain circumstances. The U.S. Supreme Court has repeatedly recognized that although the literal language of the Confrontation Clause provides for face-to-face accusation at trial, this provision does not represent an absolute bar to the use of hearsay testimony. The court has specified that an out-of-court declarant is unavailable to testify. So, in Patrick Brown's statement, it says that it's admissible only if it bears adequate indicia or of reliability. Reliability can be inferred without more in a case where the evidence falls within a firmly rooted hearsay exception. The tension between the confrontational clause and admission of hearsay testimony was considered under circumstances remarkably similar to those presented. And the trial court ruled that the child's statement during a medical examination was an exception to that hearsay rule. Excuse me. So basically they're saying that the hearsay evidence and all of this and the confrontation clause is not valid. So then the prejudice resulting from Lila's appearance at trial was brought up. Patrick Brown claimed that the sympathy invoked by Lila's emotional reaction and the nosebleed when she attempted to testify, combined with the evidence that she had been raped by someone, inflamed the jury to return a guilty verdict despite the questionable hearsay identification. He contended that because the child's two appearances prejudiced him before the jury, and a mistrial should have been declared. Mr. Brown has failed to specify the statute under which a mistrial should have been granted. Upon motion of Patrick Brown, a mistrial shall be ordered, and in a jury case, the jury dismissed when prejudicial conduct in or outside the courtroom makes it impossible for the defendant to obtain a fair trial. So it has long been held that the trial court has broad discretion in ruling on a motion for a mistrial under that particular article, Article 775 of the Code of Criminal Procedure, and that such a motion should only be granted where prejudicial remarks of a witness make it impossible for the defendant to obtain a fair trial. So, when Lila made her first attempt to testify and she suffered that nosebleed, the trial court carefully admonished the jury. They stated, "Ladies and gentlemen of the jury, let me remind you, you know that you are dealing with minor witnesses. I gave you a specific instruction on judging the credibility of a child witness. I would like to reiterate that instruction to you. We refer to that as a demeanor. That should be judged, should be evaluated in light of what the conduct of other children of similar age and intelligence would be under similar circumstances. I charge you further that the statements of a child witness are not to be considered as you would statements of a matured person. I told you earlier that you as jurors will be asked to decide the case based solely on the evidence and the testimony that you hear during the course of the trial, putting aside sympathy for the victim, the alleged victim, or for the defendant, passion, prejudice, or public opinion. Sometimes witnesses become momentarily incapacitated. I certainly don't want you distracted by the nosebleed incident experienced by this witness, aka Lila. So when Lila returned to the stand, she again became emotional and was not able to complete her testimony. However, the jury was again admonished that the incidents were to be disregarded. Additionally, during closing arguments and its final charge to the jury, the court emphasized that neither Lila's failure to testify nor her brief appearance in the courtroom were to be considered in reaching a verdict. So as the trial court noted in its denial of Patrick Brown's motion for a new trial, every reasonable effort was made in this case to present the victim's testimony and to permit cross-examination by the defense. There was no indication that the state contrived to display the reluctant witness, nor that Lila was allowed to remain before the jury once she was overcome by emotion. So on the contrary, the court rejected that state's third attempt to present her to testify on the stand because of the failed two attempts they already had, stating that it might prejudice the defense. They found that under those facts that the trial's court admonished were sufficient to overcome any potential prejudice arising from sympathy or passion against the victim. And according to denial of a mistrial was not an abuse of discretion, and that assignment of error was without merit. So then Patrick Brown filed another appeal, talk about the judge ordered an excessive sentence against him. So, Patrick Brown argued that his sentence to life in prison at hard labor is unconstitutionally excessive under State versus Dorothy. Patrick Brown argued that his life sentence was illegal because a transcript of his sentencing hearing was not included in the appellate record. However, the record has since been supplemented with that transcript. Neither the transcript nor the minute entry for Patrick Brown's sentence hearing indicated that the defense objected to the sentence or filed an oral motion to reconsider. The record does not contain a written motion to reconsider the sentence. The failure to move for reconsideration precluded that Patrick Brown from raising a claim about the sentence on an appeal. So furthermore, because life in prison at hard labor was the mandatory sentence under RS 1442C at the time Mr. Patrick Brown committed this crime, they rejected his argument that a lesser sentence was warranted. So in fact, the statute has since been amended to provide for a possible death penalty for the rape of a child under the age of 12. And that was in 1995 Louisiana Act 397. So now we're going to get to the errors of patent with Patrick Brown. There was a discrepancy between the sentencing transcript and the minute entry regarding Patrick Brown's sentencing. The transcript established that he was sentenced in compliance with LARS 1442C, which precludes the possibility of probation, parole, or suspension of sentence. However, the minute entry reflects only that Mr. Brown's term of imprisonment is to be served without the benefit of probation or suspension of sentence with no prohibition of parole consideration. Because the transcript prevails, the inconsistency is not a sentencing error. And so, basically, what this meant was the minute transcript said one thing the minute entry said one thing and the transcript said another. So the transcript said that he was able to get probation, parole, whatever. But the minute entry stated that he was not. So there was no other errors detected. So the conclusion of all of this, for the reasons assigned, Patrick Brown's conviction for aggravated rape of a child under the age of 12 and a sentence to life in prison at hard labor was affirmed. Since 2002, Lila, however, repeatedly asked authorities to correct the injustice and rightfully prosecute the actual perpetrator. So, yeah, this hit you with a fucking bombshell because Lila stated that she's then trying to get with the law and tell them that they prosecuted the wrong person for the crime, that Patrick Brown was not guilty of raping her, even though They based that off of the hearsay evidence of Daddy Patrick and the fact that he tested positive for gonorrhea a week prior to this examination. So, where do we go from here, right? Patrick Brown stated he was innocent from day one. Lila is now stating that he was not her attacker, and that she wished the right man who did attack her would get arrested. Okay? So, Patrick Brown served 29 years for a crime he potentially did not commit. He has been released from prison after it was revealed in court that the victim had told the prosecutors in New Orleans for over 2 decades that the man was innocent, but she was repeatedly ignored whenever she told the prosecution that Patrick Brown was not her attacker. Patrick Brown, age 49, was sentenced to life without parole in December of 1994 after he was accused of raping his 6-year-old stepdaughter. But for over 20 years, Lila had told authorities that her stepfather was innocent, and she implicated another family member who had actually bragged about raping her around the time of the crime. And according to filings of prosecutors, this was actually noted at that time. Patrick Brown, who appeared in court whenever he was being released, was just crying uncontrollably in the arms of his attorney as the decision to vacate his conviction was delivered by the presiding judge, Calvin Johnson. And Judge Johnson stated the following: "For the state to do something as horrific as this is just wrong. For us, the government, not to be better at what we do and how we do it, the wrongful conviction is the result." So, y'all, Patrick Brown was innocent. So, it remains who actually did this to this poor 6-year-old child and gave her gonorrhea. Over 29 years since the original trial, Lila appeared in the same courtroom, and she, cried and cried and cried as she spoke of how since May of 2002, when she was 14 years old, she had made repeated attempts to tell the court and district attorney's office that her stepfather had been wrongfully accused. She stated the following: "I've written over 100 letters. I mailed them to the DA's office. I've shown up unannounced to talk to someone, and I was turned around." She also spoke of her mental health struggles in decades after the rape, adding the following: "Having your voice be silenced is the worst feeling in the world." Not only did she be assaulted by rape, she contracted gonorrhea at age 6. And when she came out and said that Patrick Brown was not her attacker, and she was trying to implicate who was, her voice was silenced. They didn't want to hear it. They didn't want to go to trial again in the matter. How pathetic is that, for her voice not to be heard? This is just punishing the victim at this point. And the innocence, Patrick Brown. So, although prosecutors attempted to get Lila, then 7 years old, to testify at the trial, she was unable to do so because her nose began to bleed when she was asked by prosecutors if she knew the consequences of lying in court. The case had rested on hearsay evidence of other adults and medical evidence that was described by prosecutors as a probative but not conclusive method. On May 8th, the Civil Rights Division of Orleans Parish District Attorney's Office requested the court vacate the wrongful rape conviction of Patrick Brown, 49 at the time, who was accused of the 1994 raping of his then 6-year-old stepdaughter. During the trial proceedings, the stepdaughter did not testify. Instead, adults testified to what they believed what she said. So, it is said by Lila that she didn't actually say that Daddy Patrick was the one who assaulted her. The stepdaughter, Lila, who is now an adult at this time, denies that Patrick Brown ever sexually assaulted her, and since 2002, she said she repeatedly asked previous administrations to review the case, correct the injustice, and rightfully prosecute the actual perpetrator. And officials said of her steadfast account over those past 2 decades. So specifically, Lila had tested positive for gonorrhea infection shortly after the offense. Patrick Brown was not tested for active infection, instead for antibodies, while the other alleged perpetrator was only tested for active infection. So, that's where it comes in. Lawrence, the grandfather, who was always drunk, passed out on the living floor, ends up in the bed with the grandkids, right? Or Lamar, the cousin. They were actually tested for the actual active infection, while Patrick Brown was not tested for the actual infection. He was tested for antibodies. Had Lawrence and Lamar been tested for antibodies, this could have then proved that they could have all been positive for antibodies, right? Patrick Brown might not have been accused of the rape of Lila. But this is an injustice. This is an injustice. And this is where they're wrongfully convicted. And this one little fuck up in the criminal justice system cost this man 29 years of his life. So, the victim, Lila, signed an affidavit in 2015 that named another family member as the man who had raped her. And the Guardian understands that the DA's office is now reviewing whether any charges could be brought against that person. In court, Lila said the man had continued to harass her online in recent years and attempted to solicit photographs of her infant child. The case was eventually reviewed by Orleans Parish District Attorney's Civil Rights Division, created by the city's reformist district attorney, Jason Williams, to examine past harms in the criminal legal system. Patrick Brown had filed a claim of factual innocence under a new law as pro se application, meaning he had no legal representation. All of his previous appeals had been opposed by previous district attorney's offices and thrown out in court. Speaking in court on Emily Mall, the head of the Civil Rights Division, said the following: "For the last 21 years, through all the challenges the states had defended against, all the times courts have denied, they have done so despite the fact that Lila, in this case, has been telling them the wrong man is in prison." And Emily Mall also added the following: "The position of the state is to no longer ignore the victim in this case, who has been trying to correct the injustice." So before the proceedings began, Patrick Brown had appeared in an orange jumpsuit after he was transferred from Louisiana State Penitentiary earlier that morning. His attorney, Kelly Orions, applied to the court to allow him to wear civilian clothing before the proceedings began. Patrick Brown emerged from the courtroom wearing a navy shirt and a new pair of jeans, clutching the signed order that vacated his conviction. Asked by the Guardian how he felt holding the document, he replied, "This is not like winning the lottery. This is an act of Jesus Christ." And Orleans Parish, the county which covers most of New Orleans, has the highest per capita rate of wrongful convictions in the United States. The law enforcement fails to do their job appropriately. It is said that you need to meticulously go through the evidence. You need to, without a doubt, prove this person has no doubt in his conviction of guilt. But instead, they pin it on the first person. "Oh yeah, she said they did it. Oh, all the evidence looks like it's points to they must have done it." Then they're going to sit there and be biased and prove what they believe happened as opposed to what the actual evidence is in the case. This is based on circumstantial evidence, for one, but biased information, being just a biased officer of the law. Did you hear how Orleans Parish, which covers most of New Orleans, has the highest per capita rate of wrongful convictions in the United States? New Orleans is a small city compared to fucking Houston or any of these other major cities. But they have the highest per capita rate for wrongful convictions in the whole United States. How ludicrous is that, y'all? The jurisdiction has seen a line of so-called tough-on-crime prosecutors over the decades that was associated with sustained allegations of racial bias and systemic misconduct. The Civil Rights Division has so far intervened 284 cases since its creation in 2021. 3 years. 3 years is how long Civil Rights Division has been intervening in cases. And within those 3 years, 284 cases had convictions vacated with no further prosecution sought. How crazy is that, y'all? How crazy is that? And according to the DA's office, there was no investigations into the stepdaughter Lila's claims until a new district attorney, Jason Williams, took office, and the Civil Rights Division formally looked into the case, and Lila's voice was actually heard. Listening and engaging victims and survivors of sexual assault is top priority in this case, and that's what Jason Williams stated. He also stated that it is incredibly disheartening to know that this woman was dismissed and ignored, no matter how inconvenient her truth, when all she wanted was the real offender to be held responsible. The fact that Mr. Patrick Brown's conviction and ongoing imprisonment had on Lila, the victim of rape, was enormous as well. Lila broke down in tears as she told the court that Mr. Patrick Brown's hearing how she had spent the last 2 decades writing more than 100 letters to the district attorney's office and the court, informing them that her stepfather had been wrongfully convicted. In 2015, the victim went so far as to sign an affidavit identifying another family member as the man who had raped her. Even then, that's when the district attorney did not act until Jason Williams came aboard. The DA noted that wrongful convictions are not only an injustice for the person who has years of their life stolen by having to spend them in the penitentiary, but it's also an injustice for the victim and the people of New Orleans because the real perpetrator is left out there to harm other people. Civil Rights Division Chief Emily Moss said that Patrick Brown is now free. The person who committed the crime has failed to be fully investigated or prosecuted for nearly 30 years. In Louisiana, the criminal statute of limitations on sexual abuse crimes is 30 years from the victim's 18th birthday. The civil statute of limitations is 1 year from the date of discovery or 1 year after the victim's 18th birthday, whichever is longer. However, for Chase with third-degree rape, prosecution against the offender must have within 6 years after commission of offense. The changes with sexual battery degrees, genital mutilation, exposure to STDs, or most commonly known as HIV or AIDS, is knowing. So, Moss said, which is Civil Rights Division Chief Emily Moss, she stated the following. Excuse me. The victim has endured not just a deep trauma of sexual child assault, but the trauma of knowing the wrong man has been in prison for almost 3 decades, while the man who actually raped her was walking free. She said, "This is a very sad case, but we are hopeful that this will bring some closure to the victim, and she and Mr. Brown can move forward in the healing process." Officials have not released further information about the case, including if they have identified the suspect or plan to file charges in the actual perpetrator who committed this crime. Patrick Brown's loved ones had started a GoFundMe account to raise funds for him so he can rebuild his life, because he spent 29 years in Louisiana State Penitentiary. And this GoFundMe, I'm going to read it as it is stated, okay? "I am writing you today about a man, my uncle, Patrick Brown, who has been through a terrible ordeal. He was wrongfully accused of a crime he did not commit and spent almost 30 years in prison. However, after a long and difficult legal battle, along with the victim herself, who has insisted for 20 years that he is not the man who committed this horrible crime, she was ignored by the justice system for many years when she tried to tell them the real perpetrator was still free while Patrick was in prison for a crime he never committed. While we can all be grateful that justice was ultimately served, we cannot ignore the fact that my uncle's life has been irreparably damaged. He lost years of his life to a system that failed him, and he has been left with little to no resources to help him rebuild his life. That is why I'm asking for your help. We are currently accepting donations to support him as he works to regain his footing in the world. Any amount you can give, no matter how small or big, will go a long way in helping him to get back on his feet. Please consider donating today. We all have a responsibility to ensure that justice is served, and part of that responsibility is supporting those who have been wronged by the system. Thank you for your consideration and generosity. Sincerely, the Brown family. That is his GoFundMe, y'all. I will link that in the show notes. Y'all please be sure to click on that if y'all can, or at least share it. Get it out there, because this man spent 29 years in prison for a life he did not commit. Can you imagine having to relearn society after 29 years? 1994 is when cell phones were just like starting to come out and be popular and stuff to the public. Like, what the hell's an iPhone to him? You know what I'm saying? Like, this is crazy. This is crazy. So, Attorney Kelly Orion said that Mr. Patrick Brown never lost hope that he would be free someday. She overheard him telling a courthouse bystander that his freedom isn't a stroke of luck. In fact, Attorney Kelly Orion stated Patrick Brown said the following. He said to somebody, "This isn't like winning the lottery. This isn't an act of Jesus Christ." He said he never lost hope this would happen, largely due to his faith in God. District Attorney Jason Williams, who won election in 2020, said it was disheartening to know that the victim's insistence that Patrick Brown wasn't her attacker had not been heard for very many years. Listening and engaging to victims and survivors of sexual assault is top priority in this office. And Williams also stated, it is incredibly disheartening to know that this woman was dismissed and ignored, no matter how inconvenient her truth, when all she wanted was the real offender to be held responsible. Williams said wrongful convictions have particularly corrosive impact on the judicial system. When someone is wrongfully convicted, not only is it an injustice for the person who has years of their life stolen, but it's also an injustice for that victim and the people of New Orleans because, like he said before, real perpetrator is also left out there to harm other people. They really are just focused on spending time together now, making up for the last 3 decades that he spent in his time in Louisiana State Penitentiary with one another. In his first 48 hours of freedom, Patrick Brown was trying to acquaint himself with 2023 technology. All of it. Everything between cell phones, computers, hybrid cars, electric vehicles, debit and credit cards. All of it is very overwhelming to Patrick Brown and completely brand new to him. A 2022 study at the University of Michigan Law School from the National Registry of Exonerations found that Black people are 7 times more likely than white people to be falsely convicted of major crimes in the United States. Patrick Brown, 49, was convicted based on the testimony of adults claiming what they believed the victim had said, according to Orleans Parish District Attorney Jason Williams. Patrick Brown was an African American man, and he stated in an interview with NBC News the following. He kept repeating this line, and it is, "This isn't like winning the lottery, this is an act of Jesus Christ." He also stated that his newfound liberty was not a stroke of luck, but rather a result of perseverance and unwavering belief in his innocence. So firstly, we must thoroughly examine the evidence surrounding all of these accusations, right? It is crucial to gather all available information, including the physical evidence, witness testimonies, and the credibility of the accuser. So, no, the credibility of a 6-year-old cannot be held against her because she wasn't actually able to testify because of the nosebleed and her emotional appearance, right? So, has there been any corroborative evidence that can support or challenge the claims made against Patrick Brown? The fact that antibodies test and the real test for gonorrhea was the only exception to why Patrick Brown was found positive and the other 2 weren't, because we would never know, right? Unless they were tested for antibodies as well instead of the actual virus of gonorrhea. So, This includes the timeline of events, as well as any forensic evidence that may exist, right? Secondly, we should investigate the background of both Patrick Brown and the people that accused him of doing it. Realize that Lila was not fully living with her mom. She was actually living with her grandma and Carolyn since the age of 2. Why is that? Obviously, the mom is not stable. Something is wrong that caused that, right? Are there previous allegations or a history that might inform us about the motives of credibility of Patricia, her mom, Lamar, Lawrence? Because we all know Patrick Brown was innocent. It is not common for individuals to become misheard or misunderstood, and in some cases to pursue false allegations for personal reasons. Additionally, an analysis of digital footprints such as text messages, social media interactions, or email communications could have yielded significant insights, but technology wasn't advanced as it is now. 1994, like I said, that was just the start of cell phones and stuff coming out. I do believe pagers was the main thing at that time. That was not able to be done. It was based off a hearsay from the doctor. And after several hours of Patricia and all with her, who admittedly stated that she couldn't stand Patrick Brown. Didn't give a reason why, but yeah. Where is it? Not only should the perpetrator be held responsible for the crime he actually committed with this sexual assault against Lila, but those who actually accused Patrick Brown. That is false accusation. That's criminal mischief. Yes, it's a misdemeanor, but you should be charged with it because, damn, he lost 29 years of his life. The victim's voice could not be heard because you was writing her voice for her. Furthermore, we must consider the legal context of Louisiana, particularly its laws regarding consent and prevailing attitudes towards such accusations in the local community. As Patrick Brown was trying to state the different cases of hearsay testimony as well as confrontations, all which were denied until Williams was elected as DA in 2012. So, we must consult with legal expertise to navigate the complexities of the judicial system, engaging in a skilled defense attorney who can adeptly advocate for their defendant, and in this case, Mr. Patrick Brown, and ensure that all procedural rights were upheld and were imperative. So, y'all, luckily, even though it took 3 decades, Patrick Brown was found innocent for the aggravated rape of Lila. He is finally a free man. Lila's voice was actually heard, but the perpetrator is still out, y'all. We need to make sure that justice is held, because you were so quick to state that Patrick Brown was the perpetrator, and you didn't give a damn if it was circumstantial evidence or hearsay testimony to accuse him of being guilty. But whenever you have actual factual information on the actual guilty party and you're not doing anything to prosecute, what the fuck is wrong with the system? We need to do better. Thank you, Jason. Thank you, Jason Williams, for hearing this out, giving that victim a voice, giving her voice back, and working with the people exonerating the innocent. Patrick Brown, I hope you have an amazing rest of your life. I am sorry for the injustice that was caused, and I really truly hope that you live your life to the fullest. If you enjoyed our show, please rate and review us on Apple, Spotify, YouTube, iHeart, wherever you listen to your podcast. And be sure to come back next week for the case of the Howard Johnson sniper. Also, if you or someone you know is a victim of sexual assault, stalking, please reach out to the Victim Connect Resource Center. They are available at 855-484-2846. You can also chat online at victimconnect.org. The National Domestic Violence Hotline is 800-799-7233. And the RAIN's National Sexual Abuse Hotline, 800-656-4666. 73. Again, all of this will be located in the show notes, so please feel free to review the show notes. And until then, this is your host, Sarah Soulier. Don't forget to like, share, follow, or subscribe to Criminalist Behavior, a Louisiana True Crime podcast. You could email us any information on other cases or this case in particular. Let me know how you feel about the victim's voice not being heard, about the evidence stacked against Mr. Patrick Brown, how he was actually exonerated from the aggravated rape of this stepdaughter, Lila. I'm curious to know what you think. Also, be sure to listen for the new sound. I will let you know when I start it, and I really would like your feedback because, I know what I sound like, and I don't know, that new stuff is just crazy, man. So you can also visit us at our website, become a Patreon. We also have our December newsletter on there, but also starting in January, I am going to be doing outside of Louisiana cases. So basically any case anywhere else in the world, Texas, Brooklyn, New England, wherever. And that's going to be specifically to our Patreon until I figure something else out at this time. But I really want to focus this podcast on Louisiana because why? I am from Louisiana. Louisiana doesn't really get hurt a lot. So I really want to get these cases out there because they really need to be heard. And justice needs to be served. So thank you so much for listening. And until next time, y'all have a wonderful night. Bye.